Hello Ghana for for any obi biara aha Ghanatube so modofo snowy any I was for matana say maji akonye die no ehun say ai ensem no edos ye pa eno na mede boy say wonsom no eno eni nipa I was for entempa no di mechie na ensem bia ewo ho ana say bia ekoso ewo manganim no se memfa ensom di mechi.
The other by Dr. Amanda Odoi, challenging the constitutionality of Ghana's anti-LGBTQI bill, properly so-called the Sexual Human Rights and Family Values Bill. We'll be taking a look at the decision by the court, which says that it will give explanation to its decision latest by Friday, and so we're looking forward to the reasoning. In studio with me is my colleague and head of current affairs production here at Channel 1 Television and 97.3 City FM, Fred Tete Jabano. Thank you so much, Fred. We'll be going into it, but Jude Mensah Duncan was in court for us. He's joining us live to bring us up to speed with what transpired in court earlier today. Thank you so much for joining us, Jude. Now, the ruling as we have it is that both cases or suits have been dismissed. We know that the reasoning also has been scheduled for Friday, but what led to this dismissal? I'm sure the bench, the judges did mention what led to the arrival of that decision to dismiss these two cases.
All right, Nana, like you rightly said, both cases by private legal practitioner Richard Delasky. For him, his was a human rights case that he brought to the court. Dr. Amanda Odoi was a constitutional case. The court made it clear that once the bill hasn't been assented to by the president, it didn't have the jurisdiction to pronounce any judgment on the matter. So that was by the presiding judge, Justice Lovelace Averill Johnson. And for the Dr. Amanda Odoi case, it was also a similar judgment. It was unanimously dismissed by the 7-member panel. What we know is that the full reasons for the court's decision to dismiss the petition will be made available.
Unfortunately, we seem to have lost Jude there. We'll work the lines to bring him back on so he can speak to us more on how the decision was arrived at, although we know that the reasoning of the court is yet to be made public. But on both cases, the ruling was unanimously decided by the 7-member panel that sat on both cases. Jude Duncan is back. Sorry, Jude, we lost you along the way, but you were telling us about the unanimous decision and the court announcing that it will give its reasoning by Friday. If you can give us more on this.
Yes, so Nana, I was also saying that in the aftermath of the court's decision, the counsels for both teams, that's Dr. Amanda Odoi and Richard Delasky, met with journalists to brief them on their next line of action. So when questions was posed as to what they intended to do next, counsel Pakwesi Abedu, who is lead counsel for Richard Delasky, made it clear that they would study the contents of the Supreme Court's decision and they will make their next action known to the media in due course. For Dr. Amanda Odoi, Dr. Ernest Akon, who is lead counsel, also said same that indeed it's important that they have to go through the court's decision before they determine what their next line of action would be. But all through the proceedings, we also saw some notable persons in society, specifically in academia, also come by to witness the case. Professor Techiwa was also in court. So was Professor Adomako Ampofo was also present in court, and Professor Techiwa, in the aftermath of the case, also expressed her disappointment with the Supreme Court's decision. But she was quite confident that when they go for the review, which Dr. Amanda Odoi is still in the process of discussing with her counsel or with their legal team, they'll come together and decide on what the next line of action will be, whether go for a review or whether to just take the Supreme Court's decision as it is. Now, I also asked counsel for Dr. Amanda Odoi what their next line of action would be in the case whereby the president assents to the family values bill for it reason then to become law. And he was quite clear that they still remain opposed to the bill, they are still fighting the bill, and they will not give up in their efforts to make sure that this bill, that's the family values bill, is thrown out once and for all.
Jude, did you hear the moods about the possibility of a Supreme Court review?
Yes, so it was a major theme in the post judgment conversations with the legal teams. Journalists posed the questions to them as to whether they will be seeking reviews, and both sets of legal teams were quite clear. Their response was that they still have to study the contents or the full judgment from the apex court, after which a decision will be made. But Dr. Ernest Akun, who is lead counsel for Dr. Amanda Odoi, was quite clear when he mentioned that, of course, yes, a review will be sought, and that will determine their next line of action. But I must also add that he was quite confident that in the review process, they should be able to overturn this unanimous decision the court pronounced earlier today.
Anti-gay bill is in court let's go course of that right now.
In Article 131, the invocation of the interpretive jurisdiction is based upon an enactment or any act done under the authority of an enactment. In the instant case, there is not as yet an enactment, properly so called, since the legislative process which would transform a bill into an act with the force of law has not yet terminated. The action, if at all, the supposed interpretative jurisdiction of the Supreme Court is as yet premature, as there is nothing on which to hang the exercise of the judicial review jurisdiction of the Supreme Court. The Constitution itself has prescribed the mode by which an enactment properly so called can come into being, and by the principle of separation of powers, those processes must be exhausted to produce a tangible product that can have legal effect when properly assented to by the President, the head of the executive. Until there is presidential assent, there is no act Parliament over which the Supreme Court can act of Parliament over which the Supreme Court can exercise its original jurisdiction to strike down if found to be inconsistent with the Constitution 1992. The plaintiff's action is therefore dismissed. Now the reasons will be available by close of day on Friday. Yes, so that is it for Richard Sky. The judgment of the court is unanimous. Upon hearing the parties orally and on considering the arguments as contained in their statements, we come to the unanimous decision that the plaintiff's writ does not properly invoke the exclusive jurisdiction of this court. We are of the view that the subject of the litigation being a bill still undergoing the process of becoming law in accordance with the provisions fully set out in the Constitution, it will be premature for this court to exercise its interpretive and enforcement jurisdiction to intervene. Consequently, we think that the action fails. It is accordingly dismissed.
So for yako aba uti in semno ese ode anase anya ode day and wadintre for wadintre no ewu kimi ewo comment section no na menje bre enkinkan emofefe aha Ghanatube so ebusianfo sisiade my crown.